To disclose or not to disclose, this is vital to ensure that you are safe during and after the sale. I highly suggest going over the disclosures with your agent prior to your home going on the MLS and before any buyers see the home. We want buyers to have already reviewed the disclosures prior to making an offer, because this will help ensure that the buyer doesn't back out of the deal from things they should have already been made aware of. Hi, I'm Susan Feldman of Susan Says Real Estate and eXp Realty. All sellers and realtors have a duty to disclose facts that are material to the home, because the buyer, they have an absolute right to know what they are buying. These are called material facts, things that affect the value and desirability of your property. Essentially, this is so you don't get sued. Here in Washington, we have a massive amount of legally mandated disclosure forms that need to be filled out. This is actually a safety net, not only for the buyer, but also for the seller. Anything from whether you live on a golf course or if you have a sex offender living in the surrounding area, if you know about it, it would have to be disclosed. I'm happy to say that after 30 years of selling homes here, I have never been in a lawsuit, and I intend to keep it this way. So disclosure is a very important thing to understand. When you're selling, anything that has ever been repaired, replaced, modified, added, or fixed needs to be disclosed. If you painted the walls, changed the carpet, added new lighting, or fixed the water heater, it needs to be disclosed. One of my many common sayings to my clients is, if you have to ask me if you should disclose it, then the answer is almost always yes. Over-disclosing is better than under-disclosing, and it's going to keep you out of the courtroom. You want the buyer to know anything and everything that you know about the home, the neighborhood, and the area that could have a negative effect on the desirability or the price of the home. When you disclose properly, you don't have to worry about the buyer coming back to you later telling you that they want to go to court. The statute of limitations goes out 3 years from when you close escrow. However, don't get scared. Obviously, you can only disclose what you know about, and if there are issues with the property that you didn't know about, then the buyer would have to prove that you did know and that you kept that information from them intentionally in order to win in court. So your best course of action is simply disclose, disclose, disclose. As always, I'm Susan Feldman with Susan Says Real Estate. Feel free to reach out to me if you have questions about this topic, and if you'd like to talk to me about selling your home, I'd love to be the one to do that for you. Thank you for watching, and I hope you'll tune in next time to hear what Susan says.